Okay, the warm, fuzzy parts of the civil practice law and rules. The civil practice law and rules, section, I think it's 107 of the CLE says, the civil practice law and rules shall be liberally construed to secure the just, speedy, and inexpensive determination of every civil judicial proceedings. And there's another section that says mistakes, defects, and irregularities shall be ignored if a substantial right of a party is not affected by the mistake, the defect, or irregularity. There is, both in the civil and criminal side, what we used to call the cockamoon rule. Ah, to hell with them, what's the big deal? At the appellate level, there are all kinds of errors that may occur, but in appellate practice, there's the cockamoon rule. Well, that shouldn't have happened, that was wrong. But considering the overall weight of the evidence, we can ignore the error as a harmless error. The time limited for performing any act, except where otherwise expressly prescribed, can be extended by the court if the application for extension is made before or after the time runs out. Now, it's also warm and cozy. It sounds like everybody's dream, 2 nights before the paper is due, come true. Well, if the paper isn't ready, I can always ask for more time, and I don't have to ask for more time before the deadline. I can ask for time after the deadline. Well, that's kind of the hum that goes through the CLE, but it's sort of an ignis fatuus, a false light, because on pages 2 and 3, I decided to list a few of the more nightmarish provisions of the CLE. This warm, cozy, mistakes, defects, and irregularity may be ignored. CLE. CLE 201, the statute of limitations. No court shall extend the time limited by law for the commencement of an action. If the statute of limitations runs out on December 7th, which is tomorrow, and you serve the defendant on December 8th, well, you're only 1 day late. What's the big deal? The claim has a 6-year statute of limitations, let's say. And the moral of the story of the statute of limitations, or the theme song of the statute of limitations, is what a difference a day makes. You know? It's like good old General Blucher. If General Blucher showed up a day late, Wellington would have met his Waterloo, but old General Blucher came stumbling onto the field of Waterloo just in time. CLE 306B says the court can extend the time to serve papers after you filed them, but it has to be upon a showing of good cause for leave to serve the papers belatedly, or the interest of justice, whatever that means, dictates the extension of time to serve. Motions to re-argue and renew are subject to stringent time limitations. CLE 3012B. 3012B is a terrific section. I was tempted to say more about Barrish versus McCucci later on in the outline, but let me just mention Barrish versus McCucci right now. It's on page 2 is a cite to a case back in 1980, Barrish versus McCucci. CLE 3012B says that there's a demand for a copy of the complaint. Right. The demand for the copy of the complaint must be met within 20 days after the demand is made, or the defendant can move to dismiss the complaint on that ground. In Barrish versus McCucci, the complaint was not served within the 20 days after the demand was made. 3 months went by after that. The defense lawyer finally woke up and moved to dismiss under 3012B. The motion was denied. The appellate division took the case. The motion was denial was affirmed, but the appellate division granted leave to appeal to the Court of Appeals on a certified question, and the Court of Appeals said that as a matter of law, to be excused for a time default like 3012, you have to demonstrate an acceptable excuse and demonstrate the merits of the claim of the plaintiff. Within a year, the same sort of approach was taken to defaults by the defendant, and everybody was running around like crazy. What happened is the legislature pulled one of the teeth out of Barrish versus McCucci. And now in CLE 2005, CLE 2005, law office failures. I was busy. Dog ate my homework. That whiny tretch. The court is not bound to deny the motion on that ground. But what it remains is the other fang of Barrish versus McCucci, and that's the requirement of a demonstration of the merits of the claim, or in the case of a default by the defendant, the merits of the defendant's defense. Now, more about that. Matter of fact, the theme that kind of runs through this is the power of the pen and the enemy that time is for the practicing lawyer. That's the enemy for all of us, but the big enemy is ignoring. Remember, Don Vito Corleone, my favorite American philosopher, said that lawyers with their pens can steal more money than men with guns. I mean, there's a whole country in Central America, Panama, that was stolen by a bunch of American lawyers, including a guy named one of the famous law firm's partners was one of the people who helped Theodore Roosevelt steal the Panama Canal from, was it Colombia that they stole it from? Well, because the Great White Fleet, there was an American battleship sitting in the harbor at Panama City while they were negotiating the Hay-Bonavia Treaty. Right? But the pen is mightier than the sword. That's a friend of mine can't pronounce the word sword. Now, you've got dismissals as a sanction for disclosure misconduct, or for doing intermediate things like failing to serve a bill of particulars. And then, of course, there's always the default judgment for the failure to appear, to plead, or to proceed to trial. And here we get law office failures. Get a load of this. I love this one. You can't make this stuff up. This fairly recently, Thames Realty versus Robinson. The complaint in this action was dismissed when the plaintiff failed to appear for a compliance conference on February 6, 2008. To be relieved of a default in appearing, the plaintiff was required to demonstrate both, one, a reasonable excuse for the default, and two, a meritorious cause of action. Now, hello, anybody in there? Oh, your eyes are open. You're fogging up the mirror. Is there anybody at home? In this case, the vague and unsubstantiated allegation of plaintiff's counsel that he was unaware of the compliance conference because he was a quote-unquote busy attorney, braggart, it did not amount to a reasonable excuse. Matter of fact, it amounted to a chuckle. The court may, in its discretion, accept a claim of law office failure. In this case, the Supreme Court did not improvidently exercise its discretion, rejecting counsel's proffered excuse. You're busy. You're busy. This is a judge. You're busy. How about me? I'm busy, right? I'm a busy judge. You're a busy lawyer. I'm up here. You're down there. You lose, right? Sackcloth, if you screw up, the uniform of the day is not Dolce and Gabbana, right? It's not Hart, Schaffner, and Marx. It's sackcloth and ashes. And if you want a Latin